Welcome back to the Men's Divorce Podcast, videocast, also brought to you by Cordell Cordell. I'm Scott Trout, CEO of Cordell Cordell. And welcome back. We're going to talk in this continuing series as it relates to the impact of COVID-19 on divorce and guys, whether they're before, during, or after. We've been covering specific issues as it relates to custody and support and retirement. Today, as you may be aware, in our last two live webinars, the national webinars, we were taking questions. And we want to address some of those questions and just devote today's series to just that. And so today I'm joined by a partner, Erica Gittings, in the Wisconsin office. Erica has significant experience in litigation, and we just thought that she'd be perfect to join us to go through some of those questions. Erica, welcome.
Thank you so much for having me, and I really appreciate the opportunity to help everyone.
So before we get started, keep in mind that this should not be taken as legal advice. And I do this every time. We warn you just to make sure, because in these questions, we don't have all the facts, and we don't know necessarily, we are not looking at your decree, your judgment, your specific issues that you're dealing with. And so we're just kind of giving you some high-level thoughts. And particularly, I'm only licensed in Missouri, Illinois, and Georgia. Erica's only licensed in Wisconsin. And you may be listening from around the world in different states, in the UK, wherever it may be. That's what we're getting. And so just use this as caution. Write these down and use these as talking points to take to your attorney. Certainly, I'll talk to you a little bit about if you want to consult with us. We're available via telephone or virtual as well. I'll give you that information at the end of this video and podcast so that you can take that opportunity to do that. So again, we don't want this to create an attorney-client relationship because it can't. Again, not legal advice either. So let's just really dive right in. As you're listening, and if you think of a question that you want us to address either in another podcast or in a webinar, go ahead and submit those to coronavirus.divorce@cordelllaw.com. That's got 3 L's in Cordell Law. So CORDELLLAW.com. Coronavirus.divorce@cordelllaw.com. So, Erica, a lot of the questions that come in really deal specifically with custody. We have some issues that may deal with some support and financial, but let's just kind of go into the custody issue because that seems front and center for most guys. First one that came in from one of our listeners and viewers was, can my ex-wife hold my children from me because I traveled to Puerto Rico? She's telling me that I have to have the police forcibly remove them from her premises to get my time back. Now, I never thought I would read a question like that until now. We're dealing with coronavirus. It's crazy. So what does this guy do? He's been to Puerto Rico. Let's make the assumption that he's self-quarantined himself for 14 days. What does he do?
Yeah, I mean, that was my first question that I was going to ask, right? Is when did you go to Puerto Rico? Did you go to Puerto Rico 6 months ago, or did you go to Puerto Rico yesterday? The big thing that we all have to remember, and all parents have to remember, is that using coronavirus as an opportunity to withhold the children from a parent is not only counter to a court order and can subject you to contempt, right? And so you can make the courts mad, but ultimately we have to think about the relationships. It's unacceptable. This pandemic could be lasting for 2 weeks, 2 months, and to think that children should be withheld from their parents for 2 months is just, it's absolutely absurd. And in my opinion, really to the detriment of the children. It's selfish, it's manipulative, it's certainly something that the courts should be taking seriously. So the key that the person would need to do is like, well, what do I do? She's not going to follow the order. What do I do? So the first thing that I would do in that situation is I would contact the child's doctor. I would make sure that the person knows that I have self-quarantined for a 14-day period of time. And then I would ask the doctor to confirm. And most doctors have an electronic communication option so that you can send a request and a question in, and they will respond. Either they or their nursing staff will respond to you electronically. And so if you don't have that capability, side note, it's called a proxy access. So, contacting your child's healthcare provider and requesting proxy access so that you have the ability to communicate with the doctors and access your child's medical records. So,
Hmm.
using proxy access, I would contact the doctor and get the information and essentially get the doctor to confirm that there's no issue with your child going to you. And then the next step I would do is certainly contact an attorney right away. This could be something that could be resolved if you retain an attorney and an attorney contacting that person and giving a very stern response to what they're requesting. I'll tell you, I've had to do many of those as of late. And having that attorney make that communication to make sure they know that you're going to be taking it very seriously and you will be taking court action if you have to.
Hmm. It is something that when we tell guys to be proactive and communicate, and especially in writing, it's okay to have these communications. Specifically in this instance, where I did travel and I've quarantined, you can have that phone call, but followed up in writing again. And here's what I expect: I expect mom, if she's going to take this stance, she's not going to back off. And so what you're going to have to do is document everything and then take some steps. One of the things that we've been saying to guys is that they hear through the news, they listen to the media, closed, 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 shelter in place, and they think courts aren't open. But with the exception of just a few pockets around the country, yesterday in our live webinar, we talked about New York. Amazingly, that they are closed and they won't even accept filings, and I just can't. It boggles my mind, because we have emergency situations. So what? Maybe Erica, is Wisconsin currently just accepting new filings, emergency motions on a as needed basis?
So the first thing is in Wisconsin, actually, we have an order. Even though we have a safer at home order, there is a clear directive that that doesn't apply to placement exchanges. So in Wisconsin, we call it placement. Other states call it parenting time or custody. So exchanging the children is an exception to that order. So I agree that the first thing that people need to do is document and also be very aware of how you're communicating it. What you're writing will be an exhibit,
Hmm.
right? That's how you should be treating it. So be careful of your tone, be careful of, I mean, despite the fact that you are justifiably angry, just be very clear that this is going to be an exhibit. And so you're going to want to read that once, twice, three times, and even get an opinion of another person before you're responding to the
Hmm.
other side. Now, Wisconsin, it's going to vary by county. There is the option to pursue emergency orders, but in the event that somebody is pursuing an emergency order, they better have very clear indications to the court as to why the situation justifies withholding a child from their parent. And I'm not hearing that.
Hmm.
I'm hearing no symptoms. I'm hearing 14-day quarantine since Puerto Rico. It would be a completely different situation if somebody was just in clear violation, disregarding the safer at home order, going out and interacting with a ton of people, maybe even having symptoms. That's a completely different situation. And that's not what this person is saying that they have.
Yeah. So, next question is similar, and you see this pattern here that guys are experiencing. It's terrible. Can my ex withhold the kids from me if I'm healthy, but I'm a risk because I have asthma? I get it. You've heard the Surgeon General, some of the, Dr. Bricks, and talk about as asthma is an agitator to coronavirus. So apparently, right now, mom is saying, nope, you're a health risk. I'm not going to give you the kids. Can she do that?
My response to that would be, well, while I appreciate your concern for me,
Hmm.
right? This is about her trying to help him, which personally I would find quite disingenuous,
Yeah.
right?
Right.
So I would respond to the person, while I appreciate your concern, my understanding is that you're taking every precaution and you are isolating and I'm isolating. So because we both are following the orders and directives, I feel comfortable with continuing with placement, and I also think it's in our child's best interest during this incredibly difficult time,
Yeah.
right? The
Right.
message is, while I appreciate it, right, because
Hmm.
it could be an exhibit used later, but to withhold placement for somebody because of concern for their safety, um, that's disingenuous.
Yeah. So, I mean, I guess it begs the question. So we get these uh, issues, and the guys that are experiencing the denials of custody, what is the remedy? In Wisconsin, what is it that guys can file in an emergency manner that can either enforce their rights, or let's just say, obviously, by the time that they're filing, they've missed out, they're not getting their custody, so they want makeup time. What is it that typically in Wisconsin you can do that courts will entertain as an appropriate remedy?
So in Wisconsin, court orders are court orders for placement, right? There's nothing in the safer at home orders that is saying, okay, it's okay to violate a court order. In Wisconsin, in particular, we have a statute that's dedicated to enforcement of placement rights, to take away somebody's parenting time. There are criminal statutes that are associated with it. But practically speaking, right now, what a person can do is one, document it, and have an attorney involved, hire an attorney to try to get reason with the other side. But if they're not willing to reason, then you would file a motion to enforce placement. You can try to seek an ex parte order. My Right now, I'm operating under it's a no without asking. So asking the court for an ex parte order and detailing the circumstances, including the proof of this person withholding without any justification, and including in that affidavit the precautions that each person has already taken, and really focus it on the child, right?
Hmm.
That the child is experiencing no symptoms, neither parent is experiencing symptoms, both parents are isolating. And to go down that road and say that this other parent is saying that I should be withheld from the child, that means that this child is going to be taken from their parent for a
Right.
significant period of time potentially. It's just inappropriate. And we are getting feedback from court officials that they are taking this seriously. They
Yeah.
understand that there are some parents, now mind you, it's the minority. Most people are taking a common sense and reasonable approach to this, but the minority of people who are trying to take advantage of the system, those people who were already engaging in alienating behavior,
Hmm.
are continuing that alienating behavior. And we're really asking the courts to take this seriously and swiftly. And also, although the court may not be holding session, it's still possible in Wisconsin that you might file a motion and still be able to get a telephone appearance. Many counties are still doing telephone appearances.
Yep. I mean, a lot of this behavior is fear driven, not necessarily fact driven. An example right there about asthma, it's fear. I mean, if you look at the facts, if someone's healthy, not experiencing symptoms, haven't been exposed to someone with the virus, whatever it may be, they're fine. And keep social distancing, use the appropriate and follow the guidelines by the CDC in the 30 days to stop the spread. And it's crazy. The next question is similar. My ex wife is a nurse, still seeing patients. I offered to keep our son, and she won't allow it. Anything I can do to have him with me to keep him safer, considering she may be exposed on a daily basis and not know it for 2+ weeks?
So, the first thing that I would do in that situation is get more information as to what this person does on a daily basis. Are they an ER nurse, or are they a nurse at a pediatrician's clinic? Because many nurses are actually not having direct contact with patients. So, this needs to be a conversation. Now, that conversation should be in writing, but it should be at a tone that is appropriate. Again, one that you would expect that the court's going to be reading it, right?
Mm-hmm.
I'm concerned about our child safety. I know you are concerned about our child safety as well. So I want to take a common sense and practical approach where we are putting our child's best interests at the forefront and saying, here's what I'm doing to make sure that I'm engaging in social distancing and isolation. And I just need confirmation from you and an understanding from you as to what exposure you're having to other individuals. If this person is, say, an ER nurse who is having physical contact with patients who have COVID, I
Mm-hmm.
think that's a very different situation. And it's a tough situation, right? We know mom, nurse, you love your child, right? This is not about me wanting to take the child away from you. So see the different tone from what the other people are saying is, I'm withholding,
Hmm.
right? You're not going to get your child. And here it's have a conversation and show that you are being diligent, you are being respectful, and you're trying to be cooperative. Demonstrating that is important. But if it's a situation where, this is a situation where your child is at risk, if
Hmm.
it's one of those situations, you really do need to consult an attorney. You should not unilaterally just violate a court order because you can be subjected to contempt actions down the road, which could include having to pay attorney's fees. So in that situation, you really want to consult with an attorney before you take action and talk it through, talk about what the plan needs to be. And obviously, it needs to be swift. So I know that not many law firms are not open, but know that our firm, we're a national firm, and we have attorneys who are available to do telephone consultations, Zoom consultations. We're even doing them after hours or at night for parents who are working from home and having their children with them. So finding an attorney who can talk to you right away and you can consult and get that legal advice that you need to make sure that you're making the right decisions now so it's not a problem for you down the road.
Yeah. You know, going hand in hand with these custody issues, you're seeing large variations in how they're exercising their court ordered time. And so the next question involves what do you do about child support? So what happens here, this guy who submitted the question, is he's having more time than what the court order says. And that's because mom is either working, he's able to work from home, and he's still paying the full amount of child support, even though instead of getting 1/3 of the time, he's got 66% of the time. And yet, mom is, he's incurring more expenses than he otherwise would have because he's got to maintain the house, more food, whatever it may be. And the question really is can this gentleman suspend his support, pay less? What can he do considering he's incurring more costs than what the court order had perceived or suspected that they would be doing?
Well, one thing to keep in mind is that you cannot just unilaterally decide not to follow a court order. No attorney can tell you, oh, just don't follow that court order, because the court orders are there and you need to follow the court order. Your option is to try to pursue modifying the court order. This is a situation that it's really important to consult with an attorney to do that analysis, right? Are we talking about a difference between $25
Hmm.
per month, or is it going to be $300 a month, right? You want to make sure you have an attorney who's there, who's going to give you that cost benefit analysis and let you know, okay, here's what you could be expecting in terms of a modification. Here's what we can try to do. Perhaps the attorney can try to get a stipulation. So a stipulation is an agreement that parties enter into where both parties are signing it, and then it can be filed with the court to modify the court order.
Hmm.
And mom might be willing to do that right now during the pendency. But one thing that you can't do is do some self help right now unilaterally. That's not a good idea. The other thing you can't do is say, oh, okay, well, we'll try to work this out later. Because unfortunately, down the road, most states have a prospective modification approach, meaning that they don't go back and look at the scenario, the financial circumstances before the motion was filed. They look at from when the motion was filed going forward. And so you'll want to consult with an attorney to determine whether or not you need to get a motion on record now. You may not be able to get a hearing right now, but you might be able to preserve a retroactive
Hmm.
date. So even if it's going to be heard in June, the court would look at the circumstances as of April 3rd when you filed the motion potentially. So it varies by state. I encourage you to contact an attorney to run that analysis, and an attorney who's going to give you, solid information and honest and trustworthy information that's based off of a cost benefit analysis for you.
Right. Um, Along those lines in self help, one of the questions that was submitted was there's an order in place, and mom is to get visitation. This gentleman has, I guess, the majority of custody, but mom relocated out of state without notice, without court order. And the question now, mom apparently wants dad to send the child to another state to exercise custody that wasn't really contemplated in the decree. What can this person do? We got self-help. Should they reject it? What do they do?
So it would be really important to know what state that the person is in and making sure that we're analyzing the state laws. So in Wisconsin, for example, you can uh, have placement with a child outside of the state, but you can't for more than a 90-day period of time without following a specific notice statute. So the person should consult with an attorney right away, right? Be very mindful of the communication that you're having with the other side, because again, it could be an exhibit down the road.
Mm-hmm.
But have an attorney look through your agreement, review the state statutes to determine whether this is something that the person can or cannot do. What's important to know too is if this person is exercising placement outside of the state and you really don't have any idea what's going on, right? Is this person staying with other people? Are those people isolating? There's definitely more information as a parent you should be entitled to right now. You're entitled to know what circumstances are occurring at the other home to make sure that your child is safe,
Mm-hmm.
right? But in this situation, the person should consult with an attorney to make sure that they're correctly interpreting the decree. You should not withhold placement unless you have a basis to withhold
Mm-hmm.
placement, right? 'Cause otherwise, it could come back to bite you. And unfortunately, we don't know. You can line up different court officials. Some court officials might not take this as seriously as we'd like, but some might really be throwing down the hammer,
Mm-hmm.
and you don't want to be made an example of.
Yeah. So we have time for one more question, and this one is unique, and I've not heard this. The school where the father lives, who doesn't have placement that you would suggest in Wisconsin or for Missouri, what we call the non-custodial parent, has a distance learning program, while mother's school in the area in which she lives is closed with nothing going on, no e-learning. They're still out of school, and that's typically where the children normally go to school. The question is, can father enroll the children or the child in his school district that is actually engaged in e-learning? And he's concerned that that the school in which they normally go to isn't going to reopen. They're not going to put in place e-learning, and he wants them to at least have some education moving forward until this is resolved.
So the first thing I would do is gather information, right? And make sure that you are documenting communication to the other side, outlining, I've contacted the school that he's presently in. There is no opportunity provided for learning remotely for our child. And here is an option. I've researched it. This is an option that's available, and here's why it's in our child's best interest. And assuming that the people have joint legal custody, then it's a situation where they need to discuss it first.
Mm-hmm.
So what I'm not hearing from the caller or the question provided is what is the exact custodial decision making arrangement?
Mm-hmm.
Does mom have the sole right to make decisions, or does dad, do they both have to make the decision together? Regardless, my first step would be the same, which is to provide the information to mom, because why wouldn't you?
Mm-hmm.
Why wouldn't you want to? And I mean, she should be joining you
Right.
in that request to obtain these resources. But if she's being unreasonable, you can contact an attorney because, again, we don't know how long this is going to be going on. And so, one thing that you would want to talk to the attorney about is perhaps filing a motion to allow you to enroll. I wouldn't take any unilateral steps without
Mm-hmm.
consulting with an attorney to make sure that you're not violating a court order, because although your intentions are pure, they're great, and it's common sense, right? We should make sure that our child has some opportunity to learn during this time. We want to make sure that it's not in violation of an existing court order or a statute.
Mm-hmm.
If your agreement isn't very clear, keep in mind that just reading your agreement might not be good enough. You might also need to consult with an attorney to make sure, hey, am I violating any statutes
Right.
that exist related to this.
Yeah, that's a good point. I mean, I think what may upset judges the most is taking that unilateral action and enrolling them in a school in which they're not familiar with, or starting in a different place and where they were, different classes, and maybe even creating more stress for the child. So I think it's, again, having the conversation saying, look, they need to continue, and if they both agree, so be it. So great advice, Erica. I know guys really got some great insight as a result of your input, and much appreciated. Thanks for joining us today.
Absolutely. Thank you.
So that wraps it for the continuing series as we talk about the questions submitted by many of you out there as it relates to divorce, pre, post divorce, and even during. So continue sending in your questions to coronavirus.divorce@cordelllaw.com, and we'll continue to try to address those, whether it be in this podcast series or even during our live national webinar series that we're going to continue throughout this period of dealing with COVID-19. So please tune in and continue to watch. Look for more information about our webinars that we're going to have that's nationwide. If you have any questions, certainly, and if you want to have further consultation with us, you can call us at 866-DADS-LAW, 866-DADS-LAW, or you can check us out on the web at CordellCordell.com. Until next time.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell & Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.